Now, in a letter to State Prosecutor Advocate George Baloyi, Advocate Malesela Teffo has stated that he's now back on the Senzo Meyiwa murder trial. Earlier this month, he withdrew from the case after several heated exchanges between himself and the presiding judge, and also accused the court of bias. The matter was postponed to the 2nd of August after Teffo's withdrawal to allow for accused 1 to 4 to find legal counsel. Teffo says he's back on the case and will represent the 4 men when the trial resumes. Advocate Romeo Nthambeleni, who is a Senior Legal Analyst and a member of the South African Bar Association, now joins us for more analysis on this. A very good day to you. When a lawyer withdraws from a case, can he just return just like that?
Thank you. No, to you and the viewers. You are quite correct. When the lawyer has withdrawn for the case, he can't just return just like that. And we have all noted that there was an unceremonial withdrawal of Advocate Teffo in the proceedings in court. And if you have to return, you return in the very similar procedure by bringing a proper application to court, advancing reasons why you have to return to the proceedings. So unfortunately, this circus, which is actually happening now, ought not to actually happen. And the Legal Practice Council of South Africa has to intervene because unfortunately, the rights of these accused persons that are on the dock are going to be adversely affected by this conduct now.
So just give us a sense of how often this happens, legal practitioners walking away because of displeasure at how processes are being conducted.
No, to be honest with you, in my 15 years of practice, this is unceremonious. I've been in various courts in different matters, and I've seen how legal practitioners withdraw. But this one, because it's on the public platform, it's a case in point and a very good example of not how to actually conduct the proceedings in court. So I've rarely seen legal practitioners withdrawing matters in court on various reasons, but there is a set procedure on the withdrawal, in the proceedings. And after withdrawal, I've never seen someone withdrawing in the proceedings saying that they are not interested in handling the matter due to the reasons that they've set out, and again saying that they want to come back into the proceedings. And what is important, Desiree, is that let's not forget that in this matter, it's not a civil matter. The state is the dominus litis, and the state decides how the proceedings are conducted. And to see a letter being written in that form and making demands, it's actually unprecedented. And I've never seen that before.
In fact, that's what I wanted to ask you, that considering just the level of public interest in this case, does it not put into question the efficacy of the state in operating, in running a case? There's lots of conversations about doubts about South Africa's judiciary and its efficacy. Does this not add fuel to the fire?
Absolutely, yeah, you're quite correct. But when we are dealing with a matter and the proceedings are no longer about the accused persons, and then the proceedings are about a person who is supposed to be an officer of the court who has to administer justice and make sure that the justice is done without fear and prejudice. And you find this is actually going on. It's quite unfortunate, Desiree, because now we are not going into the proceedings and making a determination of whether these accused persons that are charged are guilty or not guilty, which is the most important thing in the proceeding that must be done. And now, instead of focusing on the matter at hand to actually make sure that the proceedings are conducted in a proper and in a dignified manner, we are dealing with matters of withdrawals, accusations of bias against the judge, and all unfounded allegations that are baseless. And obviously, it doesn't show confidence in the justice system of the country, and also the rights of the accused persons as well as the victims to get to the bottom of the matter as to what happened on that fateful day when Senzo Meyiwa was killed.
So what guarantees does the court have that Advocate Teffo will not withdraw again?
Let's not even speak post his withdrawal, because that still has to be determined by the court if he has to actually come back again. And in this matter, again, there is an important part of the proceedings being the instructing attorney, because Advocate Teffo did not instruct himself. in this matter. He must come out clear to make us to put this matter to rest as to whether he has given him the instructions to reappear in the matter. And then the procedure will be conducted in court, and the court must be given cogent reasons why he has to be given an opportunity again to be on that stand. Because what we have witnessed from the beginning of the trial up to now, the end was the trial not proceedings and wanting to get a discharge when the state has not even led their witnesses, which is in its own unprecedented. Because if you want the charges to be withdrawn against the accused, there's a procedure that must be done, that must be followed after the state has led the case, and then there's no case that is sufficient to prove, and then you use the provisions of Section 174 of the Criminal Procedure Act, and then you can't do it in the middle of the trial, and the judge cannot keep on interjecting you, telling you about the procedures that you are supposed to follow as an advocate, that you call yourself for a particular period of time. So those kind of things have to be ironed out, and then a determination will be made. He's not going to just walk back into the trial the very same way that he actually walked out. I don't think that is going to happen.
So just in terms of readmission procedure, who accepts him back? Is it the client? Is it the court? Is it the NPA?
No, the NPA, that does not have a duty in accepting him back into the proceedings. What should happen is that a proper application must be brought to court for him, asking for court to actually readmit him, and he must advance reasons why he has to be admitted, and then that will be done with his instructing attorney that has given him the instruction to actually appear and represent this accused person. Because you must not forget, Desiree, that when he withdrew himself, he was saying that he was also holding a brief on the other side, which is clearly a conflict of interest in law, unprecedented. On the other side, you are representing these accused persons against the case, and then now you also hold another brief from the family, which these are two separate matters that are not supposed to happen. So the court will make a determination whether it's going to be allowed back into trial or not going to be allowed back to trial after the reasons of his withdrawals were advanced. And you have said it in earlier that there were demands that were actually being made that he's going to come back under those conditions, and if those conditions are not fulfilled, he's not going to come back. So I don't think this is going to end now.
There could potentially be a positive development to this. A new advocate would have meant that they have to go back to the beginning of the process and restart the process, whereas if he resumes, they can just pick up from where they left off. Is that the case?
Yeah, no, absolutely, you're correct. In terms of that, if he resumes, there will be a continuation of where he actually started off. And then if there's a new advocate, obviously, the new advocate will have to go through the file and make a determination of whether he wants to, to recall certain witnesses and how he's going to actually proceed with the trial. So, yeah, the upshot of that is that the continuation will actually be an advantage of making sure that the trial is speedily, finalized, and that is very, very much important. But that determination yet has to be made.
Well, let's thank you for your time this morning and making the time to speak to us, Advocate Romeo Nthambeleni.